A bill in the House would boost protections against discrimination of older workers, protections that were weakened by the Supreme Court back in 2009. The new bill is called the Protecting Older Workers Against Age Discrimination Act, or POWADA. Joining me with the specifics, Tully Rinckey attorney Michael Fallings. Michael, good to have you back.
Yeah, thank you for having me.
Now, this law applies to everyone in the public and private sectors, this proposed bill, correct?
Correct.
And in your experience, what types of discrimination occur against older workers in federal agencies? Because some of them, hang around for a long time and like their careers.
Well, towards the end of a federal employee's career, or even in the private sector, you'll see the employers start to push them out, so to speak, where they'll want these employees to leave the workforce. I've seen discrimination in that aspect in the form of lower performance evaluations, stricter work assignments, in an effort to kind of push them out to increase levels of discipline and to set up that discipline for those older workers.
And this happens in federal agencies.
Correct.
And let's review then what the law was and what happened in 2009 that changed it.
Sure. So there's the Age Discrimination and Employment Act, which applies to federal workers as well. And the standard has been a but-for causation standard, meaning that employees, to prove age discrimination in employment, must prove that age was the but-for cause or was the reason for their termination, which overturned what was the mixed motive standard of proof, where an employee just has to prove that age was a reason. So, for example, if an employee could show, well, they used my age, my performance may have been not sufficient, but my age was a reason as well, that could still be an age discrimination violation. However, under the new standards that are put in place, that was not valid. You had to prove age was the reason, the but-for reason for a violation.
In other words, but for the age of the person, nothing bad would have happened.
Correct.
And this is what the Supreme Court ruled in a case some years ago.
Yes.
And did that seem to increase the amount of at least perceived discrimination, because the standard did change, as you said?
Well, I believe it increased actions taken by employers to let go of older employees and using reasons that weren't really the true reasons, masking it in bad performance or masking it in layoffs or budgetary reasons, when really the reason was because of their age. I think I saw an increase in that, in my practice, and because they knew it was harder for an employee to prove that age discrimination.
Right. And so if there's a bad performance review and a series of them, it's pretty hard to say the but for, because the employer has something, well, no, it's not the age. Here's the last 5 performance reviews.
But for is a higher standard. Having to prove that but for versus a mixed motive does make it tougher for an employee, especially when the employer is building that case against the employee for their so-called legitimate reasons to discipline an employee.
We're speaking with Michael Fallings. He's an attorney with Tully Rinckey, which represents federal employees. And so tell us about this new bill, who's behind it, and what would it do?
Well, it would go back to the mixed motive standard. The new administration has, I think for the reason we've been discussing, has seen this uptick in employees being removed and employers masking the real reasons for the removal, masking the age discrimination behind it with so-called legitimate reasons. So they want to shift back to the mixed motive standard, which would align with other discrimination statutes and their standards and what employees can prove.
What other discrimination types of classes would this then resemble if this becomes law?
Well, under Title VII, there's a mixed motive provisions where employees can prove discrimination based on retaliation or race using that mixed motive standard. And so the Age Discrimination Act, with this new proposal, would shift it back to what the Title VII standards are resembling.
What happens if someone is older or they are in one of those protected classes and their performance really is bad? How does that resolve in general, in your experience?
Well, if their performance really is bad, that's going to be a reason for an employer to discipline an employee. But I think an employee also needs to be aware of whether or not their performance is just becoming bad towards the end of their career. What I often see is an employee has been with this employer for 10, 20 years, doing the same work. And then all of a sudden their performance has just become bad. And maybe it's because a new supervisor come in, maybe there's a new policy in place or something like that, but they know their job. So if that's the case, and let's say the supervisor has some legitimate basis behind it, employee could still consider using reasons of age discrimination and filing litigation to prove that this discipline is wrongful.
All right. And again, who is behind the bill, and is there bipartisan support as far as you can tell?
Yes, from what I see, there is bipartisan support.
And should this become law, what do you advise employees to do if they feel like they can sense this kind of discrimination coming on?
Well, consider filing claims through the available avenues that federal employees or even private sector employees have. Contact local counsel if you need assistance in filing these claims. And yeah, if these actions are being taken, think about whether or not it is because of their age or because, they've been with this company or with the government for a lengthy amount of time.
Michael Fallings is an attorney with Tully Rinckey. Thanks so much for joining me.
Thank you.
And we'll post this interview at federalnewsnetwork.com/Federal Drive. Subscribe to the Federal Drive wherever you get your podcasts.